Well, thank you for joining us. My name is Austin Parrish. I'm the Dean at UC Irvine School of Law and have the privilege of being the past president of the Association of American Law Schools. Welcome to the AALS Teach-In webinar series on professional independence and the legal profession. This is a six-part series focused on issues related to professional independence in the legal profession. The session is open to students and faculty, and staff at law schools throughout the nation, and also lawyers and law firms and others in the legal community. For the students that are joining us, please be sure to check the webpage. If you've completed 5 of the 6 webinars, then we have a certificate of completion that's available for you. And we're also sponsoring a student write-on competition, student paper writing competition that we hope you'll consider participating in. Today, we have an absolute fabulous panel. Today's session is at a crossroads: U.S. anti-corruption policy and the changing landscape of international enforcement. It's organized by Indiana University's Maurer School of Law and the Stewart Center on the Global Legal Profession. This is the 5th of the 6-part series. Next week, the final session in the series will be The Profession, the Market, and the State: Reimagining Professional Independence for a Vacuum World, organized by the Harvard Law Center on the legal profession and Harvard Law School, which will be held next Wednesday, April the 29th at the usual time. I also wanted to emphasize that the recordings for the first 4 sessions are now on the series webpage with links posted in each, links are being posted in the chat so you can easily access that. That includes our session on executive orders and federal investigations involving law firms, principles for professional independence, defending America's independent judiciary and the rule of law, and professional independence and the Justice Department. Before I turn it over to Professor Krishnan and Dean Ochoa to lead today's session, I just wanted to let you know about a few upcoming ALS events that you may wish to attend, or check out the recordings of a few events that took place earlier this month. So first, I wanted to mention a webinar hosted by the Journal of Legal Education. This is Crafting Scholarly Work on Legal Education, Insight from Leaders in the Field. That was held on April 9th with a recording of the event in the chat. And so you'll see that. I hope you'll check that out. We just announced a new session for the ALS West Academic series on AI and legal education. There'll be another one on Wednesday, May 6th at 4 p.m. Eastern Time, 1 p.m. Pacific Time, on law school AI policies, frameworks, guardrails, and guidance. And so that's a new webinar on May 6th. And the recordings for the first 2 sessions of that series are now on the event webpage. Those sessions are focused on developing AI literacy for law students, held in March, and AI tools for faculty, held earlier this month. 3 other events you want to have on your calendar. The Conference on Clinical Legal Education is happening May 1 through May 5th in Portland, Oregon. The workshop for new law teachers is organized on June 4th through 6th in Washington, D.C. And of course, the annual meeting will be held January 5th through 8th, 2027 in New York. So thank you for attending this series. I'm excited. This is an amazing group of panelists. I couldn't be more proud to partner with the amazing Stewart Center on the Legal Profession. And with that, I'll turn it over to Dean Ochoa and Professor Jay Krishnan. The floor is yours.
Great. Well, thank you, Austin. I'll briefly just offer my great thanks here, and then I'll turn it over to Dean Ochoa. Let me just say, before I go ahead and describe our session today, as I say, I really want to offer my great thanks to the staff at the AALS, to you, Austin, to Executive Director Kelly Testy. And I also have to say, I have to thank the great law students at the University of Virginia who initiated, at least for me, this important conversation last month at a workshop that Professor Brewster and I were a part of. So today's panel is going to examine the future of foreign anti-bribery enforcement in light of the recent actions by the Trump administration that have raised questions about the direction, consistency, and credibility of U.S. anti-corruption policy. So for decades, the Foreign Corrupt Practices Act has positioned the United States as a central actor in the global fight against bribery, shaping corporate compliance practices, influencing international legal norms, and working in tandem with parallel regimes such as the OECD Anti-Bribery Convention and the UK Bribery Act. Recent developments, though, have prompted a renewed scrutiny of whether U.S. enforcement is becoming more selective, politically contingent, or strategically instrumentalized. And so against this backdrop, This wonderful panel brings together this group of experts who are engaged in cross-border work to explore how shifts in U.S. policy are affecting international legal practice, corporate behavior, and transnational enforcement cooperation. So let me turn it over to Dean Ochoa to get things started for us here. Thanks.
Sorry about that. I had some problem with my mouse for a second there. Thank you so much, Professor Krishnan. I really appreciate all you've done, really, actually, to organize this entire panel. And I also really want to thank Austin Parrish and Kelly Testi and the entire staff of the AALS for the work they've done to organize this series, which is, of course, incredibly important. It helps us to really feature the importance of law schools and lawyers at a time when the rule of law is under significant strain. And so I just really want to thank everyone who has supported this effort. I also want to introduce myself. My name is Christiana Ochoa. I'm the dean here at the Indiana University Maurer School of Law. And as Professor Krishnan and Austin Parrish highlighted, we are incredibly proud to be the home institution for the Milton Judy Stewart Center for the Global Legal Profession, which has been at the forefront of studying the importance of lawyers, not just in the United States, but around the world, particularly on issues like the ones we're here to discuss today. So because the full bios of our incredible panelists are going to be provided in the chat, and you will be able to look at those and look them up and really see the incredible work that each of our panelists have done over the course of their illustrious careers, I'll just provide their institutional affiliations and a very brief introduction of each of them before we jump into the conversation. So first we have Professor Rachel Brewster, who is the Jeffrey and Betty Sue Hughes Distinguished Professor of Law at Duke Law School. Professor Brewster is a leading expert in World Trade Organization law, anti-corruption law, and international relations theory. Welcome so much, Rachel. It's great to have you here with us. Thanks. We also have Professor Paul Stephen, who is both the John C. Jeffries Jr. Distinguished Professor of Law and the Lewis F. Ryan Research Professor of Law at the University of Virginia Law School. His career is greatly esteemed. We're delighted to have you here with us, Professor Stephen. He is an expert in international business, international dispute resolution, and comparative law. Welcome, and thanks for being here with us. Our third panelist is Professor Hannah Buxbaum, who is the Martin Luther King Professor of Law at the UC Davis Law School. Professor Buxbaum is the president of the American Society of Comparative Law and a leading expert in international jurisdiction, international litigation, and comparative law. And she is no stranger to Indiana University Maurer School of Law, and we're so thrilled that she could join us tonight as well. And finally, we have Mr. Kunle Ajegbe, who is a partner at the Lagos, Nigeria law firm of Aiden Partners. Mr. Ajegbe is one of Africa's leading commercial litigators and has been a champion of rule of law initiatives in Nigeria for over 25 years. He has been a great friend and partner to the Stewart Fellow on the Global Legal Profession, and in so many ways, just a terrific source of expertise to us over many, many years. And so we're just really delighted that you will also get to enjoy his expertise and knowledge. Thank you all really for being here with us. So I'm going to start the conversation by asking Rachel to open the conversation by providing us with some background on the state of the current landscape. So Rachel, for the audience's benefit, can you please just provide us with a sketch of the legal framework governing foreign bribery and international corruption? So specifically, we're talking about the FCPA, the Foreign Corrupt Practices Act, the UK Bribery Act, the FARA. What are the key statutes, if there are others beyond those, and how do they orient to the problem of corruption domestically and internationally? And also, how do those international agreements like the OECD Anti-Bribery Convention and the United Nations Convention Against Corruption, interact with those domestic frameworks? In other words, how do treaties drive enforcement, or how does enforcement drive or shape treaties?
Absolutely. So thank you so much to you, Dean Ochoa, and to the AALS for inviting me to speak here tonight. It's such an honor to be able to talk about the Foreign Corrupt Practices Act and other forms of anti-bribery legislation. So I want to start by just providing some background on how national anti-bribery legislation, starting with the Foreign Corrupt Practices Act. So the Foreign Corrupt Practices Act was passed in the late 1970s, coming out of the Watergate hearings. It really has two main parts. The first part is what it's famous for, which is its anti-bribery provisions, but it also, importantly, is a corporate accounting statute as well. So in addition to banning foreign bribes, the Foreign Corrupt Practices Act requires public corporations who list on any American exchange to have good accounting procedures and to push those down to all their majority owned and wholly owned subsidiaries. And in that way, the Foreign Corrupt Practices Act not only kind of criminally bans bribery, but does a lot of work to make sure that corporations know what their subsidiaries are doing and kind of not allow them to kind of put their head in the sand about what foreign subsidiaries might be up to. So the Foreign Corrupt Practices Act has very broad jurisdiction. It applies to three main groups. The first one is any U.S. citizen or firm. So if you are a citizen or a green card holder, you are covered by the Foreign Corrupt Practices Act anywhere you go in the world. The same for any firm that is headquartered or has its principal place of business in the United States. You are covered by the Foreign Corrupt Practices Act. The second major hook for jurisdiction is any public company that lists on an American exchange. And so this means that any major foreign corporation that chooses to access US capital markets by listing on one of exchanges is also bound by the Foreign Corrupt Practices Act. This is really important because it gives the DOJ and the SEC jurisdiction to go after not only domestic corporations that might be bribing overseas, but also foreign corporations that might be bribing overseas. In the political economy and thinking about the foreign corrupt practices, this is really essential for the DOJ to be able to put forward kind of a nationality neutral enforcement strategy, right? So it's not just that we go after American corporations, but we go after American corporations when they bribe, but also their major foreign rivals. We might go after Exxon, but we're also going to go after Shell. The third major group that's covered by the Foreign Corrupt Practices Act is any person acting within the territory of the United States. So if you're a foreign national and you come to the United States and you try and bribe a foreign government official, you too are covered by the Foreign Corrupt Practices Act. So for those individuals or parties that are covered by the FCPA's anti-bribery provisions basically prohibits any covered person from paying or offering to pay. The bribe doesn't have to be successful. Only offering a bribe is sufficient. The FCPA bans covered persons from paying or offering to pay anything of value. So anything of value can be certainly cash, but also travel. It can be employing government officials' children if they are not, suitable for the job. So offering anything of value to a foreign government official in order to obtain or retain business. So there is this business nexus link for the Foreign Corrupt Practices Act. So the Foreign Corrupt Practices Act, as I said, was passed in the 1970s, but while it was only occasionally enforced until basically the early aughts. But nonetheless, there were a lot of people within the United States who were interested in having the FCPA enforced more robustly. But there was this concern that it would only be used against American corporations, and they didn't want to put American corporations at a disadvantage. So one of the major things the US did was not only try to ramp up our own enforcement at the DOJ and at the SEC, but also to push internationally for an international treaty that would get other countries also on board with an FCPA-like criminal statute of their own. And so the US chose to do this at the OECD, the Organization for Economic Cooperation and Development, because the idea was that it was a smaller organization than something like the UN, and the OECD had all the major multinationals would be headquartered in OECD countries. So if other OECD countries also agreed to police their multinationals or allow the US to police their multinationals, then that would be sufficient to achieving the US's enforcement goals. And so the OECD treaty was negotiated it was signed in 1997, entered into force in 1999 and requires all of the signatories to essentially pass their own version of the FCPA, which they could more strongly or weakly enforce. But more importantly, I think, to help the United States in their prosecution of the FCPA and to kind of give legal aid to the United States. So after the OECD treaty is formed, you see the United States in the early aughts really ramp up FCPA prosecutions. And so this is where the FCPA, kind of shifts from being a bit of a sleeper statute to suddenly being on the minds of every corporate general counsel in the country. Suddenly, the US really cares about foreign bribery and it is willing to put major penalties behind it. So you get some blockbuster cases. Kind of one of the big early ones was the Siemens case, where the US and Germany worked together to prosecute Siemens for their overseas bribery. And you get a penalty in the early aughts of $1.6 billion. So that gets a lot of people's attention that the US is now serious about the FCPA. And until this most recent administration, even under the first Trump administration, the US basically kept up that level of intensity with the FCPA. The US now is not the only country to be serious about foreign corruption. As Dina Choa mentioned, the UK also has a similar law called the Bribery Act. It mimics the FCPA in many ways. The two major differences is that instead of applying to firms that list on a British exchange, they have their Bribery Acts applies to any foreign firms that access the UK consumer market. So if you do business in the UK, then you're covered by the UK Bribery Act. It also has something called the adequate procedures defense. Basically, if you can show that you have a really good compliance program, it's a complete defense. Whereas in the US, showing that you have a good compliance program really is only a mitigating factor in sentencing. I think that actually these two systems are the adequate procedures and the mitigation it's not as much of a difference as it sounds, but I'm happy to talk about that in the Q&A. Since then, a number of other countries have also become quite serious about enforcing foreign bribery laws. So the Canadians have passed something very similar to the FCPA and have gotten more serious about enforcement. The French have done so as well. And the Swiss and Brazilians are also really aggressive anti-bribery enforcers. So let me leave it there and kind of hopefully launch our discussion with that.
Yeah, wonderful. Thanks so much, Rachel. So let me just and that was wonderful. Let me just move to Paul and ask you, Paul. I mean, you've had decades of experience working around the globe on matters related to this subject. So when countries formally adopt treaty obligations under these instruments, implementation, as you well know, can vary widely. And so given your expertise, can you just tell us to what extent we're seeing genuine convergence in enforcement standards versus sort of more superficial harmonization that masks persistent national divergence?
So first, I'd like to thank you, Professor Christian, for inviting me to this. I'm honored to be part of this panel. And thank you to Dina Choa as well for moderating. And thank you to Professor Brewster, who shows all glory to University of Virginia, where she was one of our star students. So answering your question, I think the treaty developments in the field are part of a complicated history, which I can't do justice to, but I'll try and hit the high points. The U.S. Dipping its toe into these waters was really a product of Watergate and the Cold War. That it looked really bad for multinational corporations, particularly those associated with the U.S. military-industrial complex, to go around bribing people. It tended to play into the narrative of our adversaries. And so we adopted a law, and for the first year or two, a lot of multinationals were, upset and investing a lot of legal resources in coming into compliance. But it kind of petered out for a while. And during the Reagan administration, we heard complaints that echo some of the complaints that President Trump articulated last year, which is that U.S. firms were being singled out, and the immediate response in the 80s was the narrow, I would say cosmetically, really, the scope of the statute with respect to U.S. firms. Then, with the collapse of the Soviet Union and the rise of globalization, two things happened. One at the economic level and the other at the legal level, which is how we're getting the treaties, in case you were worried I would never get there. The rise of the global capital markets meant in particular that U.S. Capital markets were particularly attractive to more and more firms, and more foreign firms were also doing business in the United States, which reinforced their appetite for U.S. capital. And that's tremendously important because, as Professor Brewster indicated, one of the important hooks for the coverage of the statute is access to U.S. capital markets. So in the course of the 90s, more and more non-U.S. multinationals became exposed to liability, and the U.S. used that opportunity to bargain through the OECD with the major multinational host countries, the major exporters of capital, to end up with a treaty that obligated every country to have something like the U.S. OECD package as part of their domestic law. And that gave the U.S. both a carrot and a stick. The stick was more and more of your firms are exposed to our jurisdiction, and we're prepared to go after them if you don't. And the carrot is that if you take the initiative, we will cooperate with you, but we will let you take the lead. I think that's pretty much what happened with Siemens. I think it started in Switzerland, which ironically is not an OECD member. And then the U.S. Took up the challenge, but the German government appreciated that it would work better if they were in charge and the U.S. was willing to cooperate with them. It's also, I think, worth noting so first of all, so the treaty structure really made a difference in both having the major capital exporting states recognize the legitimacy of anti-corruption regimes focusing on the payers of bribes rather than the recipients. Secondly, it sort of legitimized the idea that any country could go after any firm as long as there was a jurisdictional hook, and the U.S. jurisdictional hook was fairly capacious compared. I'll leave it to Professor Buxbaum, who knows a lot more about this subject than I do, but I would argue that the FCPA is a pretty capacious in picking up firms. From the start of the aughts on, we had a significant ramping up of prosecution by the United States. Initially, I think with cooperation coming principally from the UK and Germany, later France, and more generally now, I think the treaty structure has created a mechanism for encouraging home states, states that host capital exporting firms, that this is a legitimate concern. It also, I think, happens to be a good thing. I think that anti-corruption rules not only improve the environment in the countries where bribery is taking place, but it also encourages firms to organize themselves more transparently, to have good order and discipline. I sometimes draw an analogy to the law of armed combat, which some people, including elements of the current U.S. administration, complain limits war-making capacity. But I think actually good order and discipline makes war-making more effective. And I think the same is true with anti-bribery legislation, that firms themselves want to be in control of their far-flung actors, their far-flung representatives. They want accountability of them, and paying bribes is just one of the things that allows people in the far-flung firm to slip from central control in a way that harms the firm. The practice point that I wanted to emphasize is at least in the United States, a lot more work has been invested, a lot more enforcement resources has been invested in going after firms than after individuals. I think this is characteristic of white-collar criminal enforcement generally. So there are prosecutions of people outside the C-suite typically, but fairly senior management outside the C-suite. And those cases actually go to trial. But the criminal prosecutions of corporations, to date, we have yet to have a case go to trial. They get settled, and they get settled on terms that I think are pretty favorable to the government, with significant financial settlements, but more importantly, substantial compliance commitments, substantial commitment to training people, to improve resources for monitoring. And quite frankly, this is why, as a practice area, this has made a huge difference to uh, global law, big law, as well as global accounting, because of the investment in compliance, I think has been at least as great, maybe greater than the investment in dealing with investigations brought by the government. There's much more to say, but I'll leave it there.
Yeah, thank you so much. That was wonderful. So let me actually, move to you, Hannah. You're, of course, a leading expert on international jurisdiction, and you've written extensively on international litigation. So I guess my question for you is that does it really matter if the U.S. scales back local enforcement efforts, given that we now have these international anti-bribery treaties? And connected to this, and given what our co-panelists have just said, would you like to offer your thoughts on how international agreements interact with these frameworks? And thank you for being here as well.
Oh, thanks for the invitation. I will join the other panelists in thanking the AALS and my former colleagues at the Maurer School of Law for organizing all of this. Really happy to talk about these issues. So, in terms of whether the lack of enforcement or a lack of enforcement by a particular country would matter, given that we now have international treaties. I just want to emphasize what Professor Brewster was saying in laying out the architecture, which is in this case, the international treaties, and it's the OECD convention, but also, of course, the UN convention that followed, the Convention Against Corruption. So these treaties are not substitutes for domestic legal regimes. What they do is they advance domestic legal regimes and they deploy domestic enforcement resources in the service of what we hope now is a shared goal. So, the one primary objective of the treaties is simply to extract a commitment on the part of all member states that they will criminalize certain behavior and will prosecute it where appropriate. So if that commitment is not upheld, in other words, if the member states don't, in fact, enforce their own national anti-corruption laws, then the international treaty is not doing any work. So it really is important that the law be enforced. And I want to pick up another point, which is if you think about the architecture of the international treaties, I would say there are really two major components. So one is the commitment to criminalize certain acts and to prosecute violations of those acts. And the other one, as Professor Brewster again said, is a commitment to provide legal assistance to other countries, to provide resources and to help coordinate transnational investigations. And there again, it is important that countries follow through on that commitment as well. So one of the challenges with the FCPA and with this global or international regime in anti-corruption is there's kind of a baked-in conflict of interest for countries, if you will, because often their own multinationals will say, well, wait a minute, if you're only using these laws to prosecute us, that's just putting us at a competitive disadvantage out there in the international markets. And so we need to see that foreign entities are being prosecuted as well. And so you need, in an ideal world with the international conventions, all countries would be prosecuting their own corporations. because then it functions as a kind of system of jurisdictional allocation where we say, okay, take care of the behavior of your own corporations out there in the world, and we will take care of ours, and we will help exchange legal assistance, information, investigation resources, and so forth. But where you have uneven patterns of enforcement, that can start to fall apart a little bit. And there, and if you have patterns of enforcement where where a country seems to be going more after foreign corporations than its own, then that again injects a complication into this system. And I will, I would say that this surfaced a little bit in the DOJ memo last year when there was a reference to the fact that, well, actually the companies that engage in the most foreign bribery are foreign companies, as we can see by our own enforcement patterns in the United States, which I think, well, I'll leave that one for a moment. But I think this is the difficulty. It's that the international architecture simply doesn't work well if you don't have vigorous in enforcement by all member states. And certainly the observers like Transparency International that track enforcement patterns under these laws have really flagged for years an enforcement deficit from their perspective, really across the board. So I think that's one of the challenges for this regime. And I will stop there for the moment.
Excellent. Thank you, Hannah. This is a great conversation so far. I really appreciate it. I sort of have my own list of follow-ups for each of you, offline, because I'm sure we're going to have some good questions coming from the audience as well. And please feel free to use the chat to submit questions. Kunle, I want to turn to you. We've been talking about the FCPA a lot. We've talked a little bit about the UK's statute. We've mentioned the Canadian statute. We've talked about international treaties, but your context is really different. So you have been a prominent practitioner within a legal market that as you know, has specifically been noted frequently and maligned in terms of the prevalence of corruption, which is, your country, Nigeria. You have been a true on-the-ground rule of law champion in this environment. And so with that foundation in mind, let's turn to the current moment. In February 2025, as you know, the Trump administration paused the FCPA enforcement, and the subsequent DOJ guidelines refocused priorities on cartels, national security, and protecting U.S. economic competitiveness. What has been the practical shift of the practical impact of that shift in Africa and in Nigeria specifically? And what does it signal, in your view, about the future of American anti-corruption leadership and the ways that leadership has palpable effects in countries like Nigeria?
Thank you, Dean Ochoa, and it's a pleasure to be here. Thank you to AALS. Now, straight away to your question, let me just give you an interesting figure. In 2009, a Halliburton subsidiary, and I believe that my audience is quite familiar with Halliburton. A Halliburton subsidiary in Nigeria was fined over 400 million US dollars. It was implicated in, and this is a matter of a public record now, it was implicated in a bribery scandal involving its activities in Nigeria with Nigerian government officials. And that is just one. And it's interesting that figures tend to illustrate much more than what we can say. That scandal will possibly not have come to light, but for the impact of the FCPA. Now, as to your question, one word explains the situation, even though there is a pause, and the pause thankfully is over, but one word just explains it: uncertainty. And uncertainty is bad for business. I have the privilege of advising both local and international businesses in Nigeria and across Africa. And uncertainty is something that business of all stripe do not like. So that's one big problem. Secondly, and this is quite important from somebody who resides outside the US, I'm not a US citizen. The US since 1977, when the FCPA was enacted into law, has, whether deliberately or not, assumed leadership of the anti-corruption fight worldwide. In many ways, that is a good thing, and it has tried to level it and standardize the practice of anti-corruption through international cooperation, the OECD, the UK Bribery Act. I mean, those are standard bearers. Now, please note what I said. The US has assumed, maybe that was not the intention at the onset in 1977 when the FCPA came into effect, but that was the consequence of it. And that is a good thing because it has set the standards of good corporate behavior, not just in the US, but globally. So anybody from Africa who wants to do business in the US knows that, look, there's a standard I must comply with, which again is a good thing. Now, for any reason whatsoever, whether it's a pause that has ended, but again, we've seen that subsequent to the pause, the guidelines that have been issued by the DOJ have in many ways sort of constrained, sort of limited. We can play with words here, but it's sort of shifted the focus to what appears to be much more important things under the America First idea. I'm not in a position to make a comment about the America First principle, but the signal that it telegraphs to the whole world, to people in sub-Saharan Africa, is uncertainty, and it is not a good thing for business. So it almost seems like, well, maybe you could do these kinds of bad behavior and it will not elicit the attention of the US government. That might appear to be the signal that is being telegraphed. Of course, there's nothing to say that that is the intention, but that might be the way it is being received. Of course, for me as a legal practitioner and for the business law community that I belong to, regardless of what is being telegraphed, what we still counsel strenuously is that there's no option to compliance. So what it just simply means is that it has unloaded the burden of due diligence, of corruption risk management onto corporates rather than, strictly speaking, the US government. Again, in those kinds of atmosphere, there are loopholes, there are black holes you could fall in through. But taking a longer term view about it is that from a legal and investment point of view, the current administration would eventually leave office. It remains to be seen whether a new administration would, in fact, throw away everything about there being no pause and therefore just continue as if there was never a pause, in which case there's a risk for businesses. So in all of this uncertainty, and I go back to that word again, in all of this uncertainty, businesses, from my point of view and from what I know on the ground, are just being advised, continue compliance with the FCPA as if there was never a pause. That still remains the best bad option in the circumstances. I do not know whether the focus on cartels and transnational criminal organizations would see a focus on Africa or any part of Africa for that matter. I do not know. I suspect that in the interim or in the immediate, the attention is on Latin America. But wherever the attention, the regulatory and the legislative attention shifts, it's just best that businesses, wherever they might be in this part of the world, should continue to comply. I would say that it's a bit, I'm careful about my word, it's a bit painful that we're having to talk about pauses in enforcement. That was what governments in Africa were supposed to do, pass a law and then just throw it away or be indifferent to the law they've passed. And the consequences of the FCPA, trust me, it's much wide. Perhaps we could make an argument that it set a standard beyond the US.
Yeah,
And
sorry.
That's absolutely important. You cannot now midway, if it's a decade, 2 decades afterwards, now say that, well, maybe we should focus on something else. It is the signal that is being telegraphed that is worrisome. And that is what is giving rise to uncertainty. And the leadership which the US had assumed before, again, is a bit shaky. And so recourse in the interim is being made to the UK Bribery Act 2010, which is which has extraterritorial jurisdiction, the OECD conventions, and a couple of others, but in particular, the UK Bribery Act. So for any company out there that I've had to advise, regardless of the pause, just ignore it. I mean, to use a very frank word, carry on as if there was no pause, has been the counsel that we have been given, and be mindful of the fact that even if we remove the FCPA completely, the UK Bribery Act is also there, and it is just as tough on
Thank you.
anti-corruption.
Yeah,
Thank you so much.
Yeah, thank you so much. I really appreciate that. I'm thinking also about the one of the questions that we have in the chat here, which is on the really thinking about the effects of the pause, while it was in place, the 180 days when it was in place, and whether acts that could be prosecuted under the FCPA can be prosecuted now that the 180-day pause has been lifted. I wanted, and I wanted to also just recognize that the potential of uncertainty and risk as regulatory, having regulatory resiliency, right? The uncertainty in this case is having the effect of regulatory resilience, and that's really interesting. And so with that, I wanted to ask our other three panelists, Rachel, Hannah, Paul, if you could bring your own experiences in the countries you've worked, and the context that you've seen, whether you agree that in this moment of somewhat kind of a textured landscape on enforcement, whether uncertainty and risk is acting as a regulatory enforcer itself, worrying about the future, or whether you have a different perspective on those questions.
Christy, can I actually, so on that point, first of all, for sure, this was an announced shift in regulatory policy that did not affect the underlying law. And so even just within the FCPA ecosystem, I think it's prudent of companies to maintain their compliance programs. I think going more broadly than that, as Kunle said, there are other countries' laws, like the UK law, that could catch some conduct that might otherwise have fallen under the FCPA. But there are also other US laws. So a lot of the acts that are prosecuted under the FCPA also fall within the reach of antitrust laws, of RICO, of ordinary. So there are other legal mechanisms even within the United States that could still be deployed here. So I think it is important not to shift course in terms of compliance strategy, just in response to this one announcement regarding the FCPA itself. What I worry about is that individuals get a murky signal from all of this, right? So it's entirely possible, I think, that individuals do not understand that the FCPA is still there and all these other laws are still there, and thus they really need to still pay attention. And that's what I would worry about, is how the compliance structure within corporations is fully aligned from the top all the way through the organization, so that people understand there's still risk to this kind of behavior.
I would completely agree that there is, as you stated, that as Professor Buxbaum stated, the things that violate the FCPA violate, money laundering, the Travel Act, antitrust, lots of other statutes. And I also agree, as Professor Stefan pointed out, that it's good business to comply and have your compliance procedures be anti-bribery. I mean, bribery, whereas people think it pays, it actually isn't a good business strategy. I get worried, however, that even though the statute of limitations for the criminal aspects of the FCPA are 5 years and can even be told, that a lot of, companies are looking and saying, this administration is simply not interested, even though the DOJ has ended the pause and issued new guidance. When you look at what they're doing, basically the fraud section has lost almost at least half of its FCPA attorneys, and the ones that remain seem to be focused far more on kind of trade enforcement rather than FCPA enforcement. The US also used to have 5 dedicated FBI units to do only FCPA and money laundering. And, the reporting is that they appear to no longer have the same FBI resources. So you no longer have this pipeline of cases coming in. And I think you also don't have the fear from corporations that that the DOJ and the FBI are interested in them. So they're not interested in self-reporting. So as a result, I think, when you're in New York and DC, a lot of the FCPA attorneys just simply aren't nearly as busy as they used to be. I think one of the big questions, which I think Professor Buxbaum really kind of tees up, is like, will somebody else pick up the slack? Will we see other countries then, really increase their enforcement capability? Because they do have the UK, the French, the Canadians, they do have extraterritorial jurisdiction, and they could really work together to try and make up for a US lack of interest. I think the question is, and this is truly an open question. What will they do? I mean, so the UK, the Swiss, and the French have already announced like those three prosecutors, their agencies are going to try and work together to increase anti-corruption enforcement, but you haven't necessarily seen a big increase in the number of attorneys they have, the amount of funding. And you can kind of imagine that their governments are like, oh, if the US has stopped caring as much about the FCPA, do we care as much about anti-corruption in our laws? So I think it's really at this moment an open question about kind of what other governments are going to do and if they're going to simply follow the US's lead or they're going to try to really uphold the norm of anti-corruption and pour more resources into their enforcement.
So I want to express my full agreement with Professor Buxbaum and Professor Brewster and just make a few additional points. I've been talking to lawyers in big law and one or two multinational general counsels who believe two things are true. One is uncertainty is bad, but uncertainty includes that full enforcement could return, and they have to be prepared for that. And secondly, that effective compliance and transparency programs actually aid corporate management so that even without the ad terrorem effect of prosecution, there's an incentive to continue to invest in compliance and monitoring programs. But it's also true that without some amount of ad terrorem force, the argument about how much you invest in compliance is reduced. And so what we aren't seeing, I think, is the same level of billable hours of corporate resources being invested in compliance programs that we've seen in the past. And I'll make a general point here. I mean, the current administration was elected by the American people, whether we like it or not, to shake things up. Its mandate has seen it shaking things up in a lot of areas in which anti-corruption is only one piece. We're looking at other economic risks about interest rates, exchange rates, general instability in the world that arguably are traceable to some of the both initiatives and inattention by the current administration. And we, as in both as a nation, but also as an international community, are going to have to work our way around this. We're going to have to see greater initiatives by other states to use the resources they already have to address these problems, of which anti-corruption is a part. And we hope also that we get lucky, that things just don't get too far out of hand before people recognize the benefits of these programs and raise our investment in enforcement and compliance.
Thank you all really so much for that. I want to go back to Kunle and ask you more on this question of sort of cooperation and coordination that Professor Brewster was sort of referring to. Cooperation is just often such a hallmark of the treaty system. How much of that coordination is contingent in this situation right now on reciprocity and leverage and strategic alignment between states, rather than on neutral commitment to treaty compliance, especially if the U.S. appears to be less interested in cooperation or enforcement, as we've just been discussing. And we've just got a couple more minutes, and I know that we're eager to bring one more question into the fold. And so if you could just give us a quick response to that would be fabulous.
Okay, thank you very much. I think in the absence or in the space that we have with uncertainty, it's absolutely obvious now that the cooperation between the OECD countries, their convention on anti-bribery, and that of the UK would be heightened. I think that is going to change slowly the perception globally. Up until now, the UK has been not as stringent in terms of enforcement or prosecutions as the US are tended to be. Perhaps that might change. It's an open question, but I think with what has happened in the last few months, it is going to rewrite the rules of international cooperation, and therefore it still buttresses the point that corporations should just carry on as if there was no pause in the first place.
Great. So, because we have just a few minutes left, I want to sort of just do a bit of a round robin here and follow up on this discussion by asking the group here, and Professor Brewster, I'm happy to start with you here. So, with the federal government narrowing its enforcement postures, we've seen in the U.S. attorneys generals in different states, as well as European authorities and multilateral bodies, stepping up to fill that gap. And so I'd love to get your thoughts, and then maybe we'll just go around quickly before we wrap up here to say, Kunle has already told us about how, companies should be thinking about this in terms of the clients that he's been advising, and you've given us a sort of a hint of this as well, but maybe you could expand on that a bit more broadly for us.
Absolutely. So foreign bribery is always a multi-jurisdictional crime. I mean, the idea is that you have a corporation in one country or jurisdiction bribing in another jurisdiction. And oftentimes, so there's always two jurisdictions at least, but most of the time, they also, through all these extraterritorial laws, there can be 6, 7, 8 countries that could have jurisdiction over a single act, and there is no double jeopardy at the international level. And so, just simply resolving with one country will not solve this for you. And as you pointed out, in the United States, you could also have states attorney general, and there's no double jeopardy between state and federal prosecution. And so I think that the question here is kind of, will there be kind of more prosecutions either at the state or international level? One of the things that I think was interesting is up until this administration, even under the first Trump administration, the U.S. had actually been coordinating with other governments more to bring coordinated and sequential prosecution. So now for all the major blockbuster cases like Goldman Sachs and Airbus and Odebrecht, the U.S. had not been resolving these FCPA cases on their own. They had been working with foreign prosecutors, and the prosecutors had been coordinating and not bringing a joint prosecution, but bringing separate national prosecutions. And the U.S. would then credit the FCPA penalties for whatever they paid to the foreign government. And this was helpful because the U.S., even with other countries enforcing their laws, our criminal penalties are just so much higher than a lot of other foreign government penalties. And the DOJ's legal quality is also just really exceptional. Sometimes foreign governments have the hard time kind of getting the convictions or getting corporations to settle the way that the DOJ is very good at doing. And so I think the question becomes when the US, sadly, at least at the moment, hopefully not permanently, seems to drop out of the picture a little bit, what will the new landscape look like? And I think that that's right now, there's just a lot of uncertainty.
Yeah, yeah. Thanks, Professor Stephen.
So everything that Professor Brewster said, I agree with completely. I would just add one observation, speaking as someone who's been around Washington a very long time and seen administrations come and go. It's not unheard of for administrations to come in with some, wind in their sails and think they have a mandate to do some things and maybe break things and move fast as they do that. Uh, but usually, the last 2 years of any administration, you see people trying to return to what they used to do well, because a lot of these experiments just don't work out. And so, an optimistic story is that it will become clear to the administration that the radical changes that have taken place in the Justice Department, not just in FCPA enforcement, uh, will be seen as unfortunate, that the United States has been the world leader in white collar enforcement generally. I mean, I still would rather not be in the sights of a Justice Department compared to, say, the Fraud Office in the UK. In spite of the different political salience in the two administrations. So I'm modestly optimistic that we'll return to some kind of equilibrium and maybe learn even from a bit of the break things and move fast experience that we're going through right now. I hope so.
Thank you. Hannah?
Yeah, looking beyond just the FCPA, I think the kind of coordination and all of that Professor Brewster was describing, this is embedded in all kinds of administrative structures in the United States. So if you look at the work that is done in competition law enforcement, right? There's this very rich web of bilateral and multilateral agreements between different countries where our agencies commit themselves to working together on these inherently transnational matters. The same is true in securities regulation. So I hope actually that those habits and those practices and that reflex of engaging the United States in these larger transnational networks, like I hope that will sustain through this moment, whatever, however long this moment lasts when it comes to the FCPA regulatory policy in particular. And regarding Professor Stephen's last comment there, I mean, we could also point out the United States makes a lot of money by prosecuting these things. I think in 2024, the DOJ, it was something like $1 billion plus in penalties and so forth. So I think there are some reasons to believe that the administration will soften this current stance a little bit. I also think it's important for us to just keep watching what's actually happening, right? So I think in the first quarter of 26, there was a new investigation opened, against a corporation. There are certainly individual prosecutions that are still moving forward. So it's not like we're in a complete standstill at this point. Things are starting to move a bit. So maybe I'll share Paul's optimism that this will be a transient phase and we will move past it soon.
Thank you all so much, Professor Stephen, Professor Buxbaum, Professor Brewster, Kunle Ajebge. Thank you so much for your expertise and for your goodwill and your time today. And thank you to our audience too for joining us. It's been terrific to have you with us. I just want to remind the audience that this is one of a series in the AALS's Teach-In webinar series on professional independence in the legal profession. The next event will be next week, Wednesday, April 29th at 6 p.m. Eastern Time, 3 p.m. Pacific Time, and that will be on the profession, the market, and the state, reimagining professional independence for a VUCA world. We hope you will join us then. Thank you so much, everyone, for joining us. Have a good night.